Right out of the gate, this case escalates fast. What starts as a low-level marijuana charge suddenly connects to two separate murder cases. And with prior convictions in play, the stakes just skyrocketed.
Second, Mr. Batiste, in cause number 24, DCCR 0407, charged with the state jail felony offense of possession of marijuana.
Here's where things get serious. Those prior convictions, they enhance the punishment range. That means what might have been a lower sentence is now bumped up to 15 years minimum, all the way to life. This is how criminal history can completely reshape a case.
From October 14th of 2023. And what that means in that case is if you go to trial and you're found guilty, the range of punishment would be between 6 months and up to 2 years in prison. Do you understand?
Yes, ma'am.
So again, in 24 DCCR 0917 and 0918, you're charged in each of those cases with the first-degree felony offense of murder from January 10th of 2024. The indictment in each of those cases alleges that you were previously convicted of robbery, a second-degree felony, October 26th of 2018, and also unlawful possession of a firearm by a felon on that same day. And what that means in those two cases is that if you go to trial and you're found guilty, the range of punishment would be enhanced.
Pause right here. This is a massive decision point. The state is offering 45 years total, and the defendant is choosing to reject it. That's a huge gamble, because at trial, the ceiling isn't 45, it's life. Would you take the deal or risk everything in front of a jury?
The minimum punishment would be 15 years in prison up to 99 years or life in prison. Do you understand? And then in all three of those cases, I have here on the computer some documents, the plea bargain rejections that you've signed with Mr. Gertz, that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty. And it looks like the agreement would be for a 45-year term in the institutional division of the Texas Department of Corrections in the two murder cases, and I guess a 2-year term in that state jail felony that would run concurrently. All of them run at the same time. Do you understand the possible consequences if you go to trial and what your options are if you wanted to enter pleas of guilty? And do you want to reject?
This is exactly what judges look for, a pattern. Same type of offense, repeated while already on probation. At this point, it's not just about breaking the rules, it's about whether the court believes the defendant is willing or even able to change.
Reject those offers and have all of your cases set for trial. Okay, we'll get those cases set for trial. Obviously, if there are any pre-trial issues or legal things that we need to take care of prior to.
Sorry, give me just 2 seconds, Judge. Sorry, just to clarify, he was concerned because you said both of the priors were on the same date, and I said that was the date he was sentenced, not the date of the allegations.
Okay.
I was just clarifying that.
Okay, the convictions were from the same date.
And I was clarifying too that that's better than if it were
True.
separate days.
Right. Okay, so you want to reject those offers and have all of your cases set for trial, is that correct? Okay, then we'll get it set on the trial docket. Obviously, if there are any legal issues that we need to take care of ahead of time, get whatever you need to filed so that we can take those up prior to any trial date. That way there's no worries when we get to a trial of going forward or not.
Yes, ma'am.
And
All right.
Judge, I don't know if Mr. Coleman has decided on behalf of the state if he plans to try both of the murder cases together. The marijuana is a separate, totally separate incident, and whatever happens with that is what's
I
going
don't
to
think
happen.
that's the concern.
But I just want to.
The state intends to file, if we haven't already, a motion to consolidate these two cases in trial.
Okay, you've already filed it.
Okay. Good.
Okay.
So we would anticipate trying both of them at the same time.
Perfect. Okay, sounds
Okay.
good then.
Thank you, Judge.
All right, you may go back with the bailiff.
Thank you, Judge.
Thank you.
Thanks, Judge.
Good morning. Are you Tyron Henderson?
Yes, ma'am.
And Mr. Henderson is on probation in 3 cases. In cause number 23 DCCR 0899, on probation for theft of property. In cause number 21-38934, on probation for evading arrest or detention with the use of a vehicle. And then in cause number 22-39131, on probation for unauthorized use of a vehicle. There have been motions to revoke filed in all three of these cases. Mr. Rennick has filed motions asking that I set bonds. Okay, so the theft of property is a straight probation. These other two are both deferred. So just by the nature of looking at the dates, without getting too far into this, it appears that he was on probation for the evading and the unauthorized use, and then received another probation while he was on those for the theft of property. Is that correct?
That's correct.
And those other ones were continued
Yes, that's right.
after that violation? Okay. And there are no bonds set at this time. Mr. Smith, I'll get to you, Mr. Rennick, real quick, but what is the state's position on bonds?
The only concern I have, Judge, is the fact that he is on probation and committed a new felony offense. In fact, he was on for evading, got deferred, and has committed a new offense.
So in those motions, the allegations are, one, a new arrest for evading arrest or detention with a vehicle, an arrest for reckless driving, both of those from March 23rd of 2025, failure to provide verification of community service, out past curfew at 3:35 a.m., behind in his fees, and restitution. All right, do you want to call your client?
Judge, I don't want him to justify
Okay.
about anything. It's just basically our position is with this is that he has a home structure, he realizes he's messed up, he realizes he hasn't done his probation. We're just really asking the court to set a bond. He does want to show the court that he can comply with probation, get his classes done, his hours done. He has 3 clients.
I'm not worried about classes or hours. I'm worried about the fact that you're still getting arrested for the same thing that you're on probation for. And you've already been put on probation and given an opportunity.
And there it is, no bond. That's the court saying public safety comes first. When a judge believes someone poses an ongoing risk, especially with dangerous behavior like evading in a vehicle, release isn't even on the table.
You violated the law, you got another opportunity, and I continued you, and now there's some more violations. Based on those, and I'm taking judicial notice of the court's file, includes the motions, the administrative hearings. At this time, I feel that it isn't, especially with the nature of the offense alleged and what he's on probation for, with an evading with a vehicle, it's dangerous. You could hurt somebody, you could kill somebody, you have officers out there. Anyway, I'm going to find that it is in the best interest of the community that there be no bonds in any of your cases. We will set these for whatever y'all want to on an announcement.